Welcome to U.S. Immigration TV. Now, many people are surprised to learn that family members can petition other family members for an employment-based green card. In fact, in many cases, it's faster than a regular family petition. Now, in a previous video, I discussed and I demonstrated that it's perfectly legal for family members to petition other family members for employment-based green cards, and it is recognized and approved by the government. Now, in this video, I'll discuss the basic requirements or ingredients to petition not only family members, but other people for employment-based green cards. So let's go through the various requirements. Number one, it has to be a real job and a real business. It cannot be a made-up job or a job of convenience. You know, like a fixed marriage where people get married but they're not really living together. This cannot be a situation where a relative agrees to petition another relative for employment but they never really work for them. It has to be real. The requirements have to be met. Now, relatives has a very broad meaning or definition, including relationships established by blood, marriage, or adoption, even if distant. This could include cousins of all degrees, aunts, uncles, grandparents, and grandchildren. Also, relationships established by marriage, such as in-laws and step-family members. Number two, the employer must demonstrate they have the ability to pay the wage. And this is typically where the net income on the employer's tax returns should equal at least the prevailing wage or the salary of the alien as established by the Department of Labor. Now, I said net income, not gross income. Has to be the net income. And the prevailing wage is the standard or pretty much normal salary for that job as determined by the Department of Labor. You cannot have a situation where you say, well, this is a relative and I'm going to give them free room and board, and that's going to be their salary. No, you have to agree to pay the prevailing wage. In fact, I had one situation or consultation where this sweet elderly lady wanted to petition her caregiver, but the elderly lady was only earning about $50,000, you know, because of Social Security or things like that. And the alien's salary was about $30,000. So that's not going to be enough. Number three, the alien must have the education, skills, or experience for the job. In other words, meet the requirements for the job. For example, if somebody has never fixed a car in their life, don't tell me that your uncle the mechanic is going to petition them. However, be aware, some jobs actually do not require much experience, you know, such as a caregiver or even a housekeeper. Number four, it does not need to be a college level job or even a skilled job. Now, college level courses, you have a bachelor's degree or higher. A skilled job is a type of job that takes at least 2 years of training or experience. Unskilled, less than 2 years training or experience. Now, even unskilled jobs, such as caregivers or housekeepers, are eligible for this type of green card. In fact, it can even be no skill or experience is required for certain types of jobs. Now, I know there are certain types of non-immigrant visas like H-1B, which confuses a lot of people. H-1B, you need to be a college graduate working in a college level job. That's a temporary non-immigrant visa. This is a permanent green card, and skilled and unskilled jobs are also qualified. Number five, the employer does not need to be a major corporation or a Fortune 500 company. I know that many people say, I thought only big companies can file petitions. No. As long as the employer demonstrates a need for the worker, that there's a real job, and the employer has the ability to pay, the employer could be a partnership, a corporation, or even a sole proprietor. Number six, the employer must first make a good faith effort to recruit qualified U.S. workers. Now, this is done typically by way of newspaper ads posted in certain publications, posting the job on certain websites and at the place of employment. Now, an attorney can handle that for you because it is a very detailed and complex process. Number 7, if a qualified U.S. worker applies for the job and is ready, willing, and able to work, the U.S. worker has priority for the job. However, if after a good faith recruitment effort by the employer, there are no qualified U.S. workers who apply for the job, then the job can be certified by the Department of Labor for the alien. Now, there are many jobs where you advertise and Americans just do not want to work at that type of job, especially, for example, during the pandemic. So you're advertising the job. I guess people now are earning more to stay home than they are to work. And many people may not apply for the job, whether it's housekeeper, caregiver, or whatever. Number 8, if the Department of Labor is satisfied that the employer conducted a good faith recruitment effort, the job, of course, can be certified for the alien, and then the employer goes on to file the petition with the USCIS, the form I-140. Number 9, once that petition is approved and the priority date is current, the person can apply for their green card or immigrant visa if they are outside the U.S. And that's a very important point. If you have relatives outside the U.S. and you have a job they are qualified for in the U.S., you can petition them and they go to the U.S. Embassy, apply for their immigrant visa, and they come here. Now, although the priority date for most countries for employment-based cases is current, the process does take about 2 years. As you go through the recruitment process, you file the case with the Department of Labor, and of course, their backlog. Number 11, if you are interested, you should seek the advice of an attorney who can evaluate your situation. Now, the process is very complex, and each of the requirements has to be met. Also, an attorney can evaluate your eligibility and the alien's eligibility for this particular job in terms of the alien's experience, the employer's ability to pay, and if there are other immigration issues, such as their being out of status if they are in the U.S., if they have any issues, if they're outside the U.S., such as fraud or things like that. But this is a perfectly legal and legitimate way to bring a family member to the U.S. through an employment-based petition. And I know it's very important for people because, after all, family is the most important thing in many people's life. And you may have a job and a thriving business and have the ability to pay, and you have a qualified relative for that job. And I know many people think that who can you trust more than a family member in many situations? So if you conduct that good faith recruitment effort and no qualified U.S. worker applies, perhaps your relative could qualify. Now, I'm going to be taking some of your questions on this very interesting subject because I was overwhelmed by the response I have received on this whole concept and idea of family petitioning family for an employment-based green card. Many of you did not even realize that. So I'm going to be taking some of your questions in the next video. So make sure to like, share, and subscribe to this channel. I'm Michael Gurfinkel, and thanks for watching U.S. Immigration TV.